Thanks for joining us. I remind senators that the Senate has resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and should be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how they were adopted. I particularly draw the attention of witnesses to an order of the Senate of 13 May 2009 specifying the process by which a claim of public interest immunity can be raised. I think you're probably pretty familiar with those. Before I invite you to make an opening statement for the Hansard record, could you each please state your full name and the capacity in which you appear today?
Thank you. Catherine Jones, Deputy Secretary, National Security, Criminal Justice Group, Attorney General's Department.
Anna Harmer, Acting First Assistant Secretary of the National Security Law and Policy Division of the Attorney General's Department.
Simon Lee, Acting Director, Electronic Surveillance Policy Branch, Attorney General's Department.
And Daniel Abraham, Acting Assistant Secretary, Electronic Surveillance Policy Branch, Attorney General's Department.
I didn't catch that. Were all four of you in an acting capacity?
I'm not. No, I'm doing my normal job.
Okay, I might come back to whether we should attach any significance to that in a moment. Do you wish to make a brief opening statement and then we'll go to questions?
I would like to make a brief opening statement, and I would just say to that point that the three officers here are incredibly experienced and have been working on these areas of telecommunications and data retention for some period of time. Thank you for the opportunity to appear before the committee today. The department previously appeared before this committee in April 2014 to discuss the broad concept of reforming the Telecommunications Interception and Access Act. Since that time, the government has introduced the Telecommunications Interception and Access Amendment Data Retention Bill. As this committee has heard before, telecommunications data provides critical support to law enforcement and security agencies in the performance of their functions. This committee has received in-camera evidence from ASIO and the Australian Crime Commission to that effect. Those agencies, as well as the AFP, the New South Wales Police, South Australian Police, Victoria Police, have given extensive statistical evidence and detailed case studies to the current inquiry by the Parliamentary Committee on Intelligence and Security, demonstrating the unique importance of data to a very wide range of investigations. This committee is examining the reform of the TIA Act. The proposed data retention obligation would represent the single largest reform to that Act since its introduction in 1979. That bill is currently being examined in depth by the Parliamentary Joint Committee on Intelligence and Security. The department has made a submission to that inquiry, as have our portfolio agencies. I'd like to take the opportunity to highlight a few of the key features of that measure and a number of related issues. The Data Retention Bill proposes to introduce a record-keeping obligation on Australian service providers. The bill would require service providers to retain a subset of their telecommunications data, limited to 6 categories of data for a period of 2 years. This reflects regulatory approaches in other industries, including in the banking and finance industries, where inadequate commercial record keeping has undermined national security and law enforcement investigations. Schedule 2 to the bill amends existing provisions in the TIA Act to redefine which agencies may access stored communications and telecommunications data. Schedule 3 to the bill introduces comprehensive record-keeping obligations on agencies that access telecommunications data, as well as creating an oversight mechanism for the Commonwealth Ombudsman. The purpose behind the introduction of a mandatory data retention scheme is clear. International law to which Australia is a party recognises Australians have a right to security of person, which requires the government to protect a person's physical safety and the right to life. That means we must have an effective criminal justice system and the capacity to undertake preventative operational measures to protect people from the worst behaviour of others. The Australian Government also has an obligation to provide the right to an effective remedy for victims of crime. That means agencies need the investigative tools that will enable offenders to be brought to justice. The government believes that effective access to telecommunications data is critical to the government meeting those responsibilities. In investigating past crimes, deterring and preventing future crimes, Australia's agencies have come to rely heavily on telecommunications data. This should not be surprising given how heavily the broader Australian population and the criminal element within the broader population have come to rely on communications technology. As the agencies testified on Friday, and I note in particular the evidence of the New South Wales Police, Victoria Police, South Australia Police, ASIO and the AFP to this committee, this data is a staple of modern investigations. It is particularly necessary during the early stages of investigating crimes, when telecommunications data availability can often determine whether or not an investigation can succeed and the human rights of the victim can be protected. Unfortunately, rapid changes in technology mean that newer services have far less, and in some important cases, no meaningful data that can be made available in response to lawful process. The largest industry participants, Telstra, Optus and Vodafone, have given evidence that their business practices are creating significant gaps in agency capability. In the words of the Australian Federal Police Commissioner, Andrew Colvin, we cannot afford to rely on luck to see if the provider that the criminal has chosen to use has retained that data. Many submitters to this committee, as well as the PJCIS committee inquiry, have suggested that data retention is simply unnecessary as there are other means to obtain the necessary information. Unfortunately, that is not the case. As explained in our submission to the PJCIS, the suggested alternatives have proven to be ineffective internationally, and we can explain this further if it would assist the committee. Much has been said of the impact of the mandatory data retention on human rights, particularly the right to privacy. Article 17 of the International Covenant on Civil and Political Rights sets out the right of persons to be protected against arbitrary or unlawful interference with their privacy. In order to avoid being arbitrary, any interference with privacy must be necessary to achieve a legitimate purpose and proportionate to that purpose. The government believes that the bill meets that test. The measures are clearly set out in law. They are for the legitimate purpose of protecting the right to life and security of the person. The threats presented by terrorism, espionage and crime are real and current. Arguments about this have centred on whether mandatory data retention is a disproportionate response to these genuine threats, particularly in terms of its impact on privacy. However, the proposed legislative scheme contains sound privacy safeguards. The bill limits the categories of data to be retained, with the details to be prescribed by regulation, which is common practice in legislative drafting. Web browsing history is explicitly excluded from the scheme. There is also no requirement to retain the content of communications. Law enforcement officials may only access data if a senior officer authorises it. That senior officer must consider whether any interference with privacy is justifiable, having regard to the relevance and usefulness of the data to be accessed. The Commonwealth Ombudsman will be empowered to oversee all instances in which that happens. This oversight will deter abuse. The Inspector General of Intelligence and Security will similarly oversight ASIO. Unlawful use and disclosure of a person's data by officials is also a criminal offence. The bill also limits access to telecommunications data by specifically setting, in legislation, the agencies that will be able to access data, but allow those agencies to use that information across the broad scope of their functions. Whether or not the measures in the bill are appropriate are ultimately a matter of judgment. But the department suggests that this committee, in considering whether the limitations on privacy represented by this bill are proportionate, also give due weight to the very clear evidence given by our national security and law enforcement agencies to the Parliamentary Joint Committee on Intelligence and Security. In weighing the countervailing human rights obligations, we note that last Thursday the Human Rights Commissioner stated that in giving in-principle support for the passage of the Data Retention Bill, the privacy intrusion created by data retention is a small one. I note that this committee has expressed interest in terms of the privacy impact assessment, and I can confirm that this department did undertake a privacy impact assessment in relation to the bill. It is publicly available and attached to the submission that we provided to the Parliamentary Joint Committee on Intelligence and Security. To summarise, without a legislative requirement, changing business practices within the telecommunications industry will see the police and ASIO go blind and will defeat our best efforts to stop terrorist attacks and do justice to those who are victims of crime. The weight of evidence before the two current inquiries from both agencies and industry is that the scheme is necessary. On current trends, industry will hold too little of the most important pieces of information that are needed to protect the public because industry will have no incentive to keep it for any other purposes. As mentioned a moment ago, there are no viable alternatives to the introduction of a mandatory scheme. The scheme proposed in the bill is absolutely necessary. The bill makes a significant number of compromises from the agency's ideal capabilities to protect the public. Those compromises were made to ensure the scheme is proportionate to various rights engaged, as well as the burden on industry. The Department welcomes the opportunity to provide further information about the bill to the committee. Thank you.
Thanks very much for your opening statement and for your submission both to us and to the Joint Committee. Joyce Leader.
Thank you very much, Chair. Well, thank you very much for that comprehensive and informative opening statement, Ms Jones. There's a few aspects of that I'd like to perhaps dig a bit deeper on. First of all is the evidence that there are no viable alternatives for law enforcement and security agencies. My time on this committee, we've had quite a bit of evidence that, to me, my interpretation has been to suggest that there's really no point in law enforcement agencies utilising, there's no point in the scheme because there's so many ways around it now in terms of using third-party providers, VPNs and other social media aspects. So to me the argument has been, well, this is pretty irrelevant anyway. So I'm just wondering if you could comment on that point and a bit more about how this is still relevant for law enforcement.
I might ask Anna Harmer to answer that question, Senator.
Thank you. Senator, there's probably a couple of things that I can advise the committee in terms of alternatives to data retention and also the continuing relevance of data in circumstances where there are a range of potential avenues through which surveillance could be countermanded. In terms of the alternatives, a number of commentators I think have referred to both the existing practices of industry in retaining telecommunications data and that provides an avenue to avail agencies of the data they need to conduct their investigations. And in that regard, the key thing that we would note is that telecommunications industry practices are changing and that they are changing at a rapid rate, and a number of providers have indicated in evidence before committees, most recently the PJCIS, the fact that they have significant gaps in their holdings of data, particularly in relation to more modern telecommunications services as opposed to traditional telephony services. And of course the range of services is constantly changing, and their business practices, being driven by the profitability of their particular companies, are driven by commercial needs rather than the needs of law enforcement and security agencies. So the alignment between and what has historically been a coincidence between the business practices of the telecommunications industry and the needs of law enforcement and security agencies is moving apart, and that's why there is in part the need to address the retention of telecommunications data. The second issue that's come up in some of the commentary around alternatives to data retention is the potential use of preservation notices. And in that regard, the key point is that preservation notices are only effective to be able to retain data that already exists. A preservation notice is not able to retrospectively fix the absence of data that was present for a brief period and then deleted, or only there for a transitory period to begin with. So while a preservation notice is an important aspect of the tools that are available to law enforcement agencies to assist them
it's
in
got
their
to be saved in the
investigations.
first place.
If the data is gone, it cannot assist. A preservation notice can only assist in circumstances where the data exists and it may be deleted in the near term, and then it can be retained. If it doesn't exist, it can't fix that problem. And this bill addresses the gap where data does not exist or is retained for too brief a time before law enforcement are even aware of their need to access it. So those tools are complementary, but certainly a preservation notice cannot substitute for data retention. The other point that you raised, Senator, was in relation to the possibility of third-party circumvention through use of modern technologies, and a number of commentators have talked about the ability to evade detection through the way in which they configure their use of telecommunication services. Naturally, I'm sure you'll appreciate that in this forum I would need to be careful in talking about the capabilities of the agencies, but it is fair to say that notwithstanding that there are a variety of means that those people who are engaged in criminal and security relevant activities might seek to engage in to subvert any lawful access to their data or their activities, that it remains the case. And I think the evidence from the agencies before the other committee has been unequivocal that data presents a critical and unique tool and a key lead piece of information in progressing their investigations. I think
and there is no alternative.
That's right. Yep. And there's been some evidence, I think, that's been given to this committee in camera, which has highlighted some of those examples, and where data, notwithstanding the practices of the targets of investigations, is nevertheless a key tool in being able to progress those inquiries and indeed then being able to proceed at all.
Thank you. The next question relates to the actual data sets and what's laid out in the legislation. And as you'll be aware, it's been the subject of some discussion today, particularly in terms of we've heard from previous witnesses that there's some concern that there's insufficient clarity about what those data sets actually are, and also the fact that they would be in regulations. I wasn't very clear, after questioning, I still wasn't very clear on why they didn't feel that there was, or why they felt there was insufficient information. Are you aware of any concerns in that area, or with your discussions with the working group, because there was some assertion that the working group hadn't been got back to about this particular point? So I'm just wondering if you've got any clarification you can shed on this, shed light on this.
So in relation to the data set, there's been some questions about the detail being available. I think some of those comments have gone to the detail of the data set, but it seems to me that some of the concern has also been based on a misconception that what is to be included in regulations is not available. The data set that is proposed to be prescribed by regulation is available in the document that's titled the proposed data set. It's not in the form of the regulation, but it is the one that the government has referred to the Parliamentary Joint Committee as reflecting the data that is proposed to be prescribed by regulation. So that information is available, and it sets out the detail of the data that would be required to be retained by telecommunications providers who are subject to the scheme. That data set is, as you say, proposed to be prescribed by regulation, but the overarching limitation on what data can be prescribed is contained in the primary bill, which limits the data that can be prescribed for retention purposes to 6 key classes of data, and so that limits the ability of the regulation to go beyond those categories of information.
Is one of the considerations in this is to try and make it more technology neutral than obviously one of the current limitations that's been identified in the current Act. So is that one of the things as well, so that we, law enforcement, we can sort of keep on top of emerging, sort of rapidly emerging and changing technology?
That's one of the considerations. So there are two. That's one of the features of the current casting of the proposed data set, is it does take a technologically neutral approach. We've said previously to the PJCIS that the data set mirrors the data that was prescribed under the European Data Retention Directive and learns from that experience, but has also drawn from that experience in some limitations that were identified in subsequent European studies, which identified that the technologically specific nature of the language used there was a significant limitation on the longevity and utility, indeed, of the data set that was prescribed in that context. The technological neutrality also is addressed by the inclusion of the data set in the regulations. So while it's prescribed in technologically neutral terms to have the broadest longevity possible and to describe the data by as highly
still limited in those 6 categories.
That's right. The regulations provide an ability to update the data set in the event that's required due to changes in telecommunications services and the fundamental nature of those. And industry have told us consistently that the industry is evolving at a rapid rate and there is a considerable change on the horizon. The inclusion of the data set in regulations provides an ability to update the data set, but whilst ensuring that it is limited to the 6 key categories included on the face of the bill.
And it is subject to disallowance. Now, another area...
We saw that over Christmas.
Sorry?
Our experience with what's subject to disallowance we learned about over Christmas, if you'll recall.
In relation to costs, it's been, again, an ongoing... We've had a lot of different evidence from the industry, from some of the providers themselves, and this morning again from the Telecommunications Association and the Communications Alliance. And I found it, I'm still finding it a little hard to put my finger on exactly what the costs will be and where they'll be incurred. We've heard that it's going to be at some great expense to industry, and I'm not disputing that, but in terms of trying to pin down exactly where the costs will be, we've heard evidence that it's, some of it's in storage, but others have indicated that storage costs are coming down. So others have said that it's the biggest cost going to be in architecture, in actually getting the systems engineering right, developing a system that can talk to each other. Access, so in terms of processing requests and actually doing that sort of work. And others have said that it's in security, internal and external security. Now, it seems to me that the companies would be doing all 4 of those anyway. I know you've been working with industry to further develop that through some of the work you've been doing with them, but Are you able to shed at this point any further light on what the costs currently are, what industry would incur anyway, and where the delta is in that? Because it hasn't been clear to me yet from the submissions that we've had.
Yep. As you say, the department is engaging in continuing work through a consultant to cost the impact of data retention. I think there's been some reporting of that. Naturally, costing the impacts of data retention relies on the information that industry can provide to us about the impact for them in implementing the measure. And in that regard, it is a fairly complex exercise, it's fair to say, because the diversity of industry is such that each different provider has a different range of services, a different market share, a different configuration of its networks. They use different technologies. No one provider is the same as the next, and so that's why we're engaged in a process to obtain that information directly from industry to inform an assessment of the costs of the measure. That work is ongoing, and so I'm not in a position to provide a detailed or fixed answer to this committee on the costs. What I can say in that regard, though, is that the work that we are doing at the moment suggests that the storage, or rather the retention period, has a very limited impact when it comes to the capital costs of implementing data retention. So it seems that the costs are largely in network configuration issues, but we're continuing to do that work with industry to obtain detailed costings from them.
Thank you. And final question, Chair. We heard evidence this morning from the Media, Entertainment and Arts organisation, very concerned about the impact of this on privilege for journalists, and expressed some very serious concerns that this would be a retrograde step. I noticed that you've addressed that in your submission. I'm just wondering whether you've got any additional points you'd like to raise in relation to their concerns in terms of protections for journalists.
Sure. So, as you say, we've addressed that in our written submissions and also in discussions with the Parliamentary Joint Committee on Intelligence and Security. I'm not sure there's a great deal that we can add to those. I mean, we've covered the fact that legitimate whistleblowers are not the subject of criminal offences, and outlined the restrictions on access to data. Telecommunications data is accessible to law enforcement agencies in circumstances where that access is relevant to the enforcement of the criminal law, the protection of the public revenue, or the administration of the pecuniary penalty. So in circumstances where there is no criminal offence or criminal investigation, or an investigation of that nature, then fundamentally the ability for law enforcement to access that, then it simply isn't enlivened. Naturally, of course, there are circumstances in which disclosures can be criminal offences, and there are a number of offences in the Crimes Act through which disclosure of information may potentially be a criminal offence, and in those circumstances it's appropriate that the full range of tools that are available to law enforcement for investigation of crimes broadly be available in that context. The ability to access data does not circumvent or undermine any journalist privilege. Journalist privilege is enshrined in the Evidence Act through various reforms to Commonwealth and state legislation, and that assists journalists in terms of their engagements before the courts and the requirement upon them to disclose their sources. It's not, however, a limitation that we think is appropriate in relation to the application of a criminal investigative tool of general application.
Thank you.
Thank you. Senator Collins?
Yes, thank you, Chair. I didn't want to interrupt Senator Reynolds before, so I might work backwards on some of the issues you've partly already covered. Firstly, on the issue of costs, one of our earlier witnesses today referred to a Cabinet decision on that matter. Is there any detail you can provide us about Cabinet's considerations of what costs may be met or how they may be met by the Commonwealth?
Ultimately, in terms of the overall issue of costs, it will be something that will be considered by Cabinet, but beyond that we can't sort of discuss the details of any Cabinet consideration, but it's something that will be considered by Cabinet in due course as part of the budget process.
I think this was the witness from the Communications Coalition, and I assumed at the time he was referring to media reporting of what may or may not have been a matter of Cabinet consideration. Is that a fairly accurate understanding of what he might have been referring to? Or has there been some higher level of consultation that that you could appraise us of?
I'm not sure what particular deliberations he may have been referring to. Certainly it is the case that the government has made public its decision, and indeed has announced the fact that the government has made a decision through its ordinary processes of the commitment to make a reasonable contribution towards the capital costs of implementing the data retention obligation. So that decision is one that is well known and which a number of industry participants have naturally reflected upon, and indeed has been the subject of discussions in the Joint Government Industry Implementation Working Group. So there's certainly a government decision there. I'm not sure.
Is there somewhere you can refer us to a copy of that decision, a statement that the government made, or?
I think there's an announcement. The Minister for Communications reflected upon that decision in introducing the bill into the House of Representatives, and I believe that the Attorney General has made public statements. I could check a precise reference for you, but certainly Hansard for the House of Representatives would reflect the government's decision to make a contribution to the capital costs of implementing the obligation.
I think
the other document,
explanatory memorandum might include an element of that. The question still remains is what's a reasonable contribution, and all of those things are yet to be defined.
I don't know that the explanatory memorandum contains a reference in there, but we can certainly identify some other references to that decision that we could point you to. The other document that we could point you to, which is again another document that's before the Parliamentary Joint Committee on Intelligence and Security, is the Joint Government Industry Implementation Working Group report that predominantly looks at issues around the data set that's proposed to be prescribed, but there are a couple of reflections in there ahead of that working group looking at some of the issues around costs and the engagement between government and industry on costing the impacts of data retention.
That may have been what I saw more recently. Yeah. Okay. Back then to the issue of costs. Where are we up to with the PricewaterhouseCoopers assessment? You said it was ongoing, or is it the government's considerations ongoing?
Right. The Attorney General's Department continues to work with PricewaterhouseCoopers on costing the impact of data retention. Okay.
Now, has PricewaterhouseCoopers provided an interim report or a report at this point in time?
It is working with us, and it has provided some preliminary thinking to us and some draft reports.
Okay. Now, I think the AGD Secretary took away further consideration of providing further material to the Joint Committee on the assessment of costings to date. Has there been any progress on that?
We've taken that away, and we'll be raising that with the Attorney as we committed to the PJCIS about what information we may be in a position to provide. So
there's no further progress from Thursday? Okay, fine. Going back to the issue of the proposed data set, now, Ms Harmer, I think you indicated you thought there might be some misunderstanding. I don't think that there is any misunderstanding around the proposed data set. It's pretty clear to me that the draft data set as was produced was provided to the working group, has been provided to the Joint Committee, is available obviously to us. We understand that it forms the basis of thinking for establishing the regulations. But what concerns us is that we do have, for instance, the outcome of the working group's consideration of the data set. We've got recommendations, but we still have no indication of the government's thinking about how the proposed data set might change responding to the consultations to date. It would be more helpful for us, particularly ahead of us reporting and or considering the bill, to understand, rather than the initial draft data set, what the government's thinking is post the consultation process. Now, is that going to be likely or possible?
There's a couple of things I could say there. First, I should say that I hadn't intended to reflect on this committee.
No, I understand. I didn't take it that way.
There's some media reporting and some submitters where there seems to have been some confusion. I was hoping to clarify it in that regard.
No, I'm sorry, Ms Harmer. I was responding partly to the evidence you gave to the Joint Committee last week as well. I don't think there is any misunderstanding. What we're waiting for is the government's response to the consultation process to date, so that we can see the most up-to-date version of the government's thinking about what will be in the regulations.
Right. So the proposed data set remains that which has been provided to the Parliamentary Joint Committee on Intelligence and Security. What the government has provided in addition to that is the report of the Implementation Working Group. It is fair to say that that Implementation Working Group represents a consensus view of industry representatives and government representatives on some amendments to the data set that may be appropriate. Naturally, in circumstances where the bill had been and the data set had been referred to the Parliamentary Joint Committee on Intelligence and Security, what we have done is to provide that working group report to the committee to assist in its consideration of the data set. Given that the government was a key participant in and member of the working group, naturally we support those recommendations that were put forward. It was a consensus and agreed report. And so the recommendations that have been made in the implementation working group report, I think there were 3 for modest amendments to the data set, 1 for a procedural recommendation about how any changes to the regulations might be made in future, and the balance were for changes to the explanatory material and suggestions that it might be enhanced by additional examples or clarificatory text, that the government would support those amendments, but has invited the PJCIS to give its views on the data set as a key element of the bill that is before it.
Okay. Well, that may help us understand what might be some uncertainty even today in some of the earlier evidence, because I think even members of the working group who appeared before us today were not clear that this report represented a consensus position, including the government.
It does present an agreed view. It is a joint government industry working group, and all members of the industry implementation working group were agreed on that report that was provided. Okay,
so this encompasses the government's current thinking.
Yes.
Okay, that's fine. All right, now I don't think I'll explore further here the other issues about the proposed data set. I think the evidence that various other people have raised can still stand there. I think I'll take up, Ms Jones, your offer in your opening statement for further discussion around the international experience that's been proven to be ineffective. I think that might help us in considering what has worked elsewhere and what hasn't, because we've got lengthy material about what has been established in various other jurisdictions, but an understanding about how effective those regimes have been is still open in my mind.
Thank you, Senator. And we have closely looked at the experience in many other jurisdictions to firstly ensure that we understand what their current schemes are. There have been, in various countries around the world, many schemes have been established in relation to data retention, many with similar elements to the scheme that is being proposed in the bill. And we have also sought to understand from operational experience of agencies in other jurisdictions how critical data retention has been to progressing significant both criminal and national security investigations. I will ask Ms Harmer to talk to some of the detail of the experience, but certainly the information that we've received from counterpart agencies in Europe in particular, comparing the outcomes of major criminal prosecutions in countries where they have a data retention scheme and where they haven't. And
Yes, I'm sorry, Ms Jones. Maybe I misunderstood what you were suggesting at the outset, but the issues I'm interested in, the international lessons, so to speak, are around, for instance, the length of time data is retained for, and around prior authorisation.
Right.
So we've had a range of tables and other things presented to us of the regimes that various other countries have put in place, but I maybe misunderstood you earlier as suggesting that some appraisal of the outcomes of those regimes had been conducted and that you could assist us with experience there. The actual case for retaining data, I think, is a slightly separate issue. If we take as a given that we choose to retain data, what is the best way or what's the international experience about the best framework to do that within?
So there are a couple of resources that we can point the committee to. Where I don't have precise citations with me, we may be able to provide those to the committee if that is helpful. But we've certainly had regard to the time period that other countries have prescribed for retention of data. The committee will be aware that the EU Data Retention Directive, when in force, prescribed that member states should retain the prescribed data for a minimum of 6 months and a maximum of 2 years. And there were a number of different approaches to implementing that within EU jurisdictions, and we've summarised those in a table that is attached to a submission to the PJCIS, and you have it all. We can certainly provide that. There's been a couple of different evaluative studies that have been undertaken of the approaches, at least in Europe, and there's been the evaluation of the EU Data Retention Directive, which was undertaken 5 years after its implementation, and which reflected on a number of aspects of that regime. I would probably be doing a great injustice if I sought to summarise that here, but there are a number of insights in that report in relation to the effectiveness and various aspects of the implementation of data retention there. There is also a relatively more recent Dutch study which has looked at data retention, and in that particular regard concluded that a 12-month retention period was indeed inadequate for supporting investigations. And I don't have the precise title in front of me, but we could certainly provide that to the committee as well in relation to recent studies on the retention period at least. In terms of approaches to authorisation, we've again summarised that in an annexure to our submission to the PJCIS. What I would note in that regard is that obviously a number of jurisdictions have different legal systems in which their prosecutors take on a role that is different to that in which our prosecutors would take on here. And so in some instances where it appears that a magistrate is issuing a warrant, as it were, that indeed the magistrate there is more akin to a prosecutor here in the Australian system. So there is a degree of caution there about equating what may look like a warrant in those instances with a warrant in the Australian context, in which we have quite a distinct separation between investigative and judicial functions. But there is a summary in that annexure.
Yes, no, I've looked at the summary, and that's why I was keen if you could provide further material about what we've learnt from that summary. And I suppose that's not what really occurs here in the submission. For instance, if we look at the access method, internal authorisation, warrant, internal authorisation, warrant, prosecutor, none in Finland, except for judges for traffic data. Interior Ministry. How would you describe in that table, if you were to put Australia as the authorisation method that's proposed here?
Sorry, if you could.
If you were to add Australia into this into this table, how would you describe the access method?
We would describe it as an authorisation mechanism.
Sorry?
An authorisation.
So no warrant then?
No. The Australian arrangements for access to data are pursuant to an authorisation rather than a warrant.
So internal authorisation would be the way you'd describe it?
It would be described as internal authorisation. Okay,
now the other regimes here that refer to internal authorisation, are they as loose as ours?
I'd have to take that on notice in terms of providing a detail of exactly what thresholds they provide. So if you're looking at, for example, an equivalence in terms of the level of seniority, our authorisation mechanism prescribes a particular level of seniority of the officer and particular factors that they must take into account. I would need to take on notice any comparison of the, I suppose, respective rigour of the alternate authorisation mechanisms.
Well, I mean, the process, in my understanding, is relatively clear for ASIO, for instance, and they have guidelines that IGIS monitors, but it's less clear in my mind what the authorisation process is for other law enforcement agencies. It's probably more my ignorance than anything else, but people have referred to the evidence that was before the Joint Committee last week that it would be a senior officer in the New South Wales Police Force, but what prescribes that?
So it is, I can take you through the legislative framework, and it is the legislative framework that prescribes that the officer must be in a management position within that agency. Okay. The state and territory law enforcement agencies, so 3 of them, I think Victoria, South Australia and New South Wales Police, gave more detailed evidence to the PJCIS on their internal processes, but it typically entails a commissioned officer at a particular level of seniority. I won't use the technical terminology within each of their policing frameworks at the risk of providing an inaccurate characterisation of the particular rank and title that those officers have, but the fundamental requirement for a particular level of seniority comes from the legislation, and then the accessing agencies have a framework through which they ensure that those particular management officers consider those applications and consider the statutory criteria which are specified in terms of the relevance to an investigation and the impact on privacy. And I think it was New South Wales Police, but I would have to check the transcript once it's available, that outlined the steps that an investigating officer would go through to access data in terms of going to a senior officer, making the case for access to data, why it was required in that particular instance, what the impact was, and that management level officer then making a decision to authorise that application to be made to the relevant service provider.
Okay. Now, given the climate in the New South Wales Police Force at the moment, I think that leads to some sensible further questions, which are, okay, they're the legislative criteria. What monitoring of that criteria will occur? So we're talking about the new provisions for the Ombudsman, yes. Yeah. That criteria includes requirements for record keeping, I assume?
It does. Yes.
We've had recommendations about the destruction of material. Does it currently include anything on the destruction of material?
No.
No, okay. So record keeping, what else?
So the Ombudsman, as you've reflected, so there's a completely new role for the Ombudsman. There is currently no oversight by the Ombudsman or a like body in relation to access to telecommunications data. So the bill includes a new mechanism, and indeed it increases existing oversight for access to stored communications while it is including that Ombudsman oversight. There is also a number of offences which pre-exist in both the Telecommunications Interception and Access Act and the Telecommunications Act, and those offences apply at both ends. One for officers who access data and their use of that, and there is also one at the carrier and provider end to protect their use and disclosure of information. And I think at least one witness has speculated that they would consider it to be rare for these things to be relied upon or used. That's not the case. I'm aware of a number of prosecutions in which have been pursued for improper use of telecommunications data. So that's part of the range of oversight. The Ombudsman would look at the record keeping and the thresholds being met. Officers are subject to an appropriate culture of compliance in terms of it being very clear that there are offences, post-fact oversight and managerial oversight of the use of the powers.
Senator, if I could just add to that, in terms of the role that the legislation provides for the Ombudsman, the Ombudsman will be able to assess the entire process under which the data authorisation was undertaken and the data accessed, which is a little bit broader, really, in a sense, to the warrant. The role that a judge or a magistrate plays at a warrant is at the beginning of the process, and the authority is given then to access the information. Whereas the Ombudsman will be able to see the entire process and to be able to satisfy themselves that it has been done appropriately and with good reason.
So Ms Jones, one notion that has occurred to me, and this would be applicable for IGIS as well, and it was implied to us earlier that IGIS potentially already has this power, is were the Ombudsman to say, I don't know, I'm going to randomly approve 5% of requests.
Assess, you mean? Or?
Yeah, assess. So I want to assess. So I want to start at the very beginning of the process in 5% of cases. Could that occur under the legislation?
At the application stage? No. So certainly the sampling approach which you suggested, and the Ombudsman has broad-ranging powers and ability to identify how they would go about it, and they have particular methodologies, and I'm sure they could provide some advice on the methodologies they employ for obtaining a representative sample and being able to review the process, but it is after the fact, and that's so right. they can review. They can certainly review the entire history of the matter, but it is after the fact, after the authorisation has been
No, well, I was mostly curious, and I haven't even established in my own mind whether this is a fact for IGIS, but it seemed to be suggested by an earlier witness today that IGIS did actually have a capacity for a prior assessment, but that's certainly not envisaged or possible in the current framework for the legislation.
No.
So the committee's also had evidence suggesting that the ASIO Director General in his discussions around, the former, in his discussions about the need for enhancing oversight, that prior approval might be one thing that be contemplated. Did government consider prior approval at any stage in its consideration of this process?
Senator, I think broadly the former Director General of ASIO had I think, talked about generic warrants.
Yes, that's right.
So that basically the agency would be given a broad authority under a warrant to undertake or to access data. I think one of the issues that was raised on that point is it's very difficult to understand how that might operate. It's a sort of unknown concept in a sense in terms of a very generic type of approach. And without any more information, I think it's difficult to sort of assess how that would properly work. And we haven't sort of assessed that in the context of the bill.
Okay. So that, I mean, it goes back partly to my earlier notion is that has any consideration, given the amount of concern raised by people suggesting that we should be having, and the evidence that was received last week also, we should be building into the regime some prior approval aspect. There's been no detailed consideration about how that might be manageable, even if you did look at something like a randomised spot check type method.
I mean, there's certainly been consideration. I mean, obviously, you know, there's a balancing in terms of operational efficacy and ensuring that in many of the cases when agencies are looking to obtain data, it's at the very early stages of an investigation. Time is of the essence in terms of being able to access that information. And certainly, I think numerous commentators, including members of the PJCIS and the former Attorney General, have noted the fact that if you had a warrant regime in place, it could potentially grind to a halt. I'm not talking about a warrant regime.
Okay. So, but some sort of quasi-judicial arrangement that applies in only a proportion of cases is, in a sense, a potential middle ground to what's being proposed at either end. And I'm just curious as to whether that type of regime had at any stage been contemplated. At the moment, we're looking at sort of random post-fact evaluations. Had any consideration been given to any type of pre-fact assessment? And I think the answer from what you're saying is no.
Well, and I think there certainly are some. We have looked at the extent to which authorisations, which review of authorisations prior to access could be implemented. I mean, to say it's not correct that there's been no reflections upon that. I think it's the case that we perhaps haven't contemplated a proposal in quite the terms that you've put to us just now, in terms of perhaps a sample of authorisations being reviewed prior to those being granted. But we have looked at, and indeed I think we've addressed in our submission to the PJCIS, some of the challenges around authorisation, around a sort of an alternative to the current authorisation process, bearing in mind and being quite mindful of the particular issues that have been raised both previously and now subsequently in the PJCIS hearings. There are a couple of challenges in that regard, and I think we've summarised some of those, but it is the case that well, first of all, as Ms Jones outlined, there are some challenges in the particular I suppose the framework that you would have put around such authorisation, such a process, but also one thing that we would caution is that the current process for authorisations, one of the key advantages that it does have is it involves an individual consideration of each particular authorisation and its impact, and it involves individual consideration of privacy issues. So some of the alternatives certainly that have been advanced would step away from that, and while they might provide a higher threshold for approval of access, they might dilute the very protection that is currently there in terms of consideration of privacy in that particular instance for access to that particular piece of data.
As long as that regime is working and that you are constantly evaluating that it is working.
Indeed, and the Ombudsman, of course, is being introduced into that, and that brings in a new degree of oversight through well-established methodologies. The Ombudsman has a well-established role in the telecommunications interception space, in the surveillance devices space, and in related areas, and has long engagement with our law enforcement agencies and has conducted numerous evaluations and reports in that regard, and so we would see that as the introduction of a significant piece of oversight.
It's fine, we're well of the case there. Thank you, Chair. Thank you.
Thank you, colleagues. Ms Jones, are you aware that law enforcement hasn't ground to a halt in Belgium, Bulgaria, Denmark, Greece, Latvia, the Netherlands, Portugal, Romania and Serbia, which are all countries that, according to your very helpful appendix to your submission, have some form of judicial oversight of telecommunications authorisations? Why do you think it would grind to a halt in Australia? What evidence do you have to back that up?
Well, Senator, we've obviously been discussing this with agencies in terms of their operational experience of the importance of being able to access data, information as quickly as possible, as early in the process. I note that you've listed a number of countries, but we've also looked at the experience in the United Kingdom, where they've recently had to look at the regime that they had in relation to warrants, because essentially their operational experience was that it became virtually unworkable, and that the number of successful authorisations, I think, were significantly reduced. And there was a report to the UK Parliament by the Interception and Communications Commissioner that noted that it was causing significant delay in the progress of many investigations.
Do you have any evidence in any of the countries that I just listed that law enforcement has ground to a halt, or that there's been actually any impact at all on the efficiency of law enforcement?
We haven't discussed with the specifics of those countries. Is there anything further you can add?
No, we'd have to take that on. We haven't engaged directly.
Because it's a pretty big deal to come in here and make sweeping statements like law enforcement will grind to a halt unless we're allowed to continue vast warrantless access of telecommunications data. It's a pretty big call. And you have no evidence that in any of those countries that has been the case.
We are focused on the experience in the Australian context, on talking with agencies in Australia, and this is an issue that we've discussed before the Parliamentary Joint Committee on Intelligence and Security.
Yep, and you're here now with us. What evidence have you got in the countries that either have a standing data retention regime or those in Europe that had one that was then annulled, so Germany being one example, of improvements to the rate of clearance of crimes? Is there any evidence from any country at all, actually, that you could point to where data retention has led to an improvement of the rates of crime clearance?
I think one of the challenges in that regard is the extent to which data as a single point as an investigative resource can be said by itself to improve clearance rates. And I expect you may have in mind a German report which suggests that there was a limited and perhaps what has been characterised as negligible improvement in clearance rates as a result of the introduction of data retention there. What clearance rates, of course, reflects is the extent to which the number of crimes solved as opposed to the number of crimes on hand. What data retention, what access to data does is to provide the starting point for investigations and allows them to proceed further or indeed to commence at all. And in that regard, while there is that German report, I think it was only a fortnight ago that German Chancellor Merkel indicated her intention to lobby the EU for a new data retention directive, noting the very significant importance of data retention from her perspective for German investigations.
You've still managed to avoid the question. You've got any evidence from any jurisdiction at all that mandatory data retention either reduces crime or improves the rate at which crimes are solved? You may not have it at the table, but anything at all that you could point me to?
The evidence in support of data retention is not cast in terms of clearance rates. It is cast in terms
or
of...
crime rate.
Or
crime rate. I'll take any metric you care to name.
So perhaps in that regard I could refer you to some of the evidence of the law enforcement agencies who appeared last Friday, and from an investigative perspective, it is the case that it is extremely difficult to be able to point to data as one point and one investigative tool having a direct and quantifiable impact in relation to the number of prosecutions and convictions. The way in which law enforcement agencies apply metrics to assess their effectiveness in their prosecution and convictions is not able to hinge back to a single data point. And so,
no, I'm not talking about a single data point. The whole category of data retention or metadata access in general. It's the opposite of evidence-based policy. It's anecdote-based policy.
It's policy based on very strong advice from the agencies who have responsibilities in relation to law enforcement and national security. So,
of course, they want more power. It's your job and ours to balance that power against proportionality and whether it's useful or not. I'm just asking for evidence as to whether it's useful. All right, we'll move on. Yeah, of course. Go ahead.
So I'd just like to pick up the point that Senator Ludlam has raised. Just to clarify that my own mind in terms of what you're saying that it's not, the metrics are not available at the end point where a conviction is actually recorded, but it is used in an investigative sense up front, and really statistics not kept. So I have a little submission here. So is this, you're talking about, so it's used for connections and relationships between persons of interest, suspects' movements and behaviour, events immediately before and after a crime, and to exclude people from suspicion. So is that where it is of most use, I guess, and there's no, they don't keep statistics of how and when it's used at that early stage in investigation?
So
was that correct? There's no metrics for that?
That is correct. There are metrics around the extent to which data is used in investigations, and the AFP Commissioner gave evidence again to the PJCIS in relation to the proportion of investigations that used telecommunications data, and I think those figures were around 97% of CT investigations, 100% of cybercrime investigations, and it was in the very high 80s or early 90s for child, 87% for child protection investigations and 79% of serious and organised crime investigations. I think the AFP has given evidence, I think, both to this committee in camera and to the PJCIS in relation to the use that it makes of data at the early stages of investigations. So there are some metrics that are available around the extent to which data is useful and indeed is required to progress those investigations. The challenge that I was highlighting is that it would be difficult to say, for example, that the outcomes of particular investigations in terms of prosecution or convictions would be hinged to telecommunications data. I think if I can give an example in that regard, because there's one that is a matter of detailed public record, which is the conviction secured in Operation Pendennis, which was a significant counter-terrorism investigation. The AFP has reflected that telecommunications data was a very important point of that investigation. Ultimately, extensive telecommunications interception evidence was adduced in evidence in those prosecutions. I'm not sure that we could then draw the conclusion necessarily and say that the convictions that were ultimately secured were ones that were attributed to telecommunications data, but I think I would not be misrepresenting the situation on behalf of the AFP to say that telecommunications data was necessarily critical in them being able to reach the point of obtaining telecommunications interception warrants, advancing the investigation and securing convictions.
So just on that point, it would also then be impossible, I guess, for the inquiries and the investigations that didn't proceed. So without this information, again, with the overseas experience, it's impossible to tell how many more investigations could have happened had they had access to this information that they don't, because investigations would never have started. So, of course, you can't measure that either.
That's correct. It is difficult to measure the number of investigations that have not been able to proceed because of an absence of data. There are some instances in which it's been possible to track that, and the AFP, I think, again, has given an example in its submission to the PJCIS around an operation called Operation Drakensberg, in which they were referred a number of IP addresses in Australia that were suspected of having accessed child exploitation material online. In that particular instance, because there was a quantified number of referrals, it was possible to identify how many did not proceed. But in a number of instances, and I think agencies have given evidence, it's the case that they may be provided with a lead and they are simply unable to take it further, and data may not be available for all of those instances.
Thank you.
All right, thank you. We'll move on. And just by the way, I'm not contesting whether or not this material is useful. It's whether a 2-year warrantless data retention proposal dropped across everybody whether there's any evidence that that would be useful. But I recognise, I'm surprised to hear that some of those figures were lower than 100%. I recognise that it's important. Just going back briefly to where Jacinta Collins took us on cost, do you anticipate that either an estimate of the cost of this proposal or the PwC documents themselves will be available to the Parliament before the bill is debated?
That will ultimately be a matter for the attorney and the government.
So you can't confirm whether the Parliament will know how much the scheme will cost before the bill is debated? That's not up to you?
As with all budgetary matters, it's a matter for the budget process and the government and the cabinet.
Yeah. It's a shame the Minister's not at the table. I guess we'll have to wait to estimates, but that would be the first time in my experience a bill had been debated without the government being able to tell us how much a policy would cost. Are you, as the AG's department, do you understand that you will at least know what the cost of this policy is before it's passed, or debated at least? It may not be passed.
We are continuing to engage with industry on those costs, and we are doing work on that cost, yes.
I know you're doing work on it. Do you anticipate knowing what the cost of this policy will be at the time that it's being debated by the Parliament?
Yes.
Yes.
You do, but you're not sure whether you'll be sharing that with us?
That's correct.
It'll be a matter for the government.
It will. It absolutely will. Can you just explain for us, please, just to make it clear, why the definition of data, which I understand that there's a working definition or draft definition that we've got our hands on, which is what's presently under discussion in the working group, why that definition isn't being put into the bill, why it is proposed to be introduced as a regulation at a later time?
So, as I said a little earlier, I think in answer to a question from Senator Collins, the level of detail that is included in the data set is typically reserved for regulations, while there's certainly a number of available approaches to legislation in terms of what may be included in the primary legislation and what may be included in delegated legislation. The level of detail in the data set is of a nature that is typically reserved for regulations, and also, as I said in response to a question from Senator Reynolds, it is the case that including the data set in regulations provides that ability to update the regulations in the event that is necessary in response to changes in telecommunications technology. Yeah.
Do you recognise that might be precisely what raises alarm bells? That the definition of obligations that you provide, that you lay on service providers, and that therefore wash through the entire Australian population, could be changed without recourse to Parliament?
Well, what we recognise is that it is appropriate there be limitations on the extent to which delegated legislation can be used to define the scope of a primary obligation, and so the bill that's before the Parliament circumscribes the range of data that can be prescribed by regulation by setting out 6 categories, and so the information must fall into one of those 6 categories in order for it to be prescribed. So we certainly recognise that it's possible through regulation to expand, and that's why there is I think one might describe it as a hybrid approach in which key delimiters are included in the primary legislation. The detail of the data set is in the regulation. The only thing that I would add to that is that I would draw your attention to a recommendation that has been made by the Joint Government Industry Working Group, which recommended that in light of the need for certainty for the telecommunications industry, that it would be preferable for any amending regulations, in the event the regulations were to be amended, be subject to commencement following the expiry of a disallowance period.
Yeah, I think you mentioned that before. What would be the effect on the legislation if those regs were disallowed? Would it render it functionally inoperative, or would it still function in some form?
So I was referring to any amendment to the regulations subsequently, and so obviously if in the event that the regulations were made as is currently proposed, any further amendment to those regulations, if they were disallowed, then obviously the amendment to the data set would be the amendment would not proceed, and the data set in the regulations would not be changed. In the event that no regulations were to be disallowed at the outset, then there would be no substance to the scheme in terms of the obligation.
It would be inoperative. So do you recognise that in going down this course of not including your definition of the material, which is what everybody's been wanting to know for quite a period of time in the bill, if Parliament doesn't like an aspect of it, we have no choice but to disallow the whole lot, that it makes it a much blunter instrument than being able to work through amendments? That's a risk that you are taking on.
Well, we recognise that there are a variety of approaches to prescribing the data that is to be retained, and this is the approach that the government prefers and has put before the Parliament at this point.
Okay. I don't know how much of the other witnesses' evidence you've been in a position to pay attention to this afternoon, or whether you were working on your own submission, but on a number of occasions, a number of witnesses have proposed the introduction of a public interest monitor, as exists in Queensland and Victoria at the moment. What's the view of the department and or the policy of the government on introducing a public interest monitor at the Commonwealth level to keep a bit of a public interest eye on the number of these authorisations that are made and the quality of them, I guess?
Yep. I'm not sure that I could purport to convey a government position beyond that which is reflected in the bill, which is that there is, as you will have seen, no role for a like monitor in the proposed bill, and that the bill sets out what it sees as being, what the government sees as being appropriate accountability, oversight and review mechanisms in the context of access to telecommunications data, and that's that ex post facto review through the Ombudsman, through the range of offences and through professional obligations that are placed on law enforcement officers.
Because the Ombudsman who gave evidence to us months and months ago now said they were interested in precisely the kind of role that I think you've assigned to them in the bill, but that they would need additional resources to conduct that role. Have they been granted additional resources as part of that expansion of their scope?
We've been working with the Ombudsman, but naturally any decisions in relation to resourcing would be subject to the normal budget process, but it is correct to say, and we've indicated previously, that we continue to work with the Ombudsman in relation to the resourcing they would require to support their new role in this regard.
Well, they've said they require more.
Yep.
Will there be more?
As I said, any decision on funding would be a matter for the government in accordance with the normal financial and budgetary processes, but it is the case that they've articulated the amount that they would require, and that we are in discussions with them in that regard.
Thank you. Let's just go then to the scope, because there's been quite a bit of discussion today about what's in scope and what's out of scope, and unfortunately the draft regs don't necessarily make that much clearer. And maybe starting, were you aware either of the submission that Electronic Frontiers have put to us and to the Joint Committee, or did you hear their evidence when they were giving it earlier today?
I heard aspects of it, but I can't say that I heard all of it. You may need to refresh me with a particular issue.
Just to go specifically, and Senator Reynolds put some related questions to you right at the outset, circumvention of data retention. Mm-hmm. I think you went straight to, I don't know if this was quite your wording, but illegitimate circumvention. So I guess you would mean anonymising software or using virtual private networks and so on. Are you aware of the wide variety of ways in which people could accidentally circumvent data retention by, for example, using a university network or logging onto the Parliament House Wi-Fi? I'm presuming you would agree that those systems would be out of scope of data retention.
We're aware that there are a number of ways in which people can conduct their communications and that they have a number of channels through which to do so.
Can I try and keep you to specifics rather than wandering off?
Sorry, I may have misunderstood the question. I'm not sure this particular aspect of circumvention.
So if somebody logs on to the public Wi-Fi in this building in Parliament House, would their data be retained by anybody in particular, or would that be out of scope of the national data retention regime?
So there are two specific exemptions in the bill that may be relevant, and I apologise if I don't comment on exactly how APH Wi-Fi works because I'm not familiar with the particular system.
Well, it's not a commercial service provider, I guess. It's like a public, like if a council was offering it or a library or something.
So it's free and available to the public?
That's right. Yeah, there's no login or anything like that.
So there are a couple of exemptions that apply in the bill, and this is again an issue on which we've given evidence to the PJCIS, which are intended to ensure that the data retention obligation is appropriately targeted and achieves that proportional balance between assisting law enforcement security agencies and both privacy impact and the burden on industry. There are two concepts which we've employed that are modelled on concepts in the communications portfolio and the communications framework, and so there are particular exemptions for services that are provided in a same place and ones that are provided to an immediate circle. So the immediate circle ones, they wouldn't be applicable here. Immediate circle ones apply to entities such as universities, which you mentioned in your question, or corporate networks. So, for example, where a company provides services to its employees, but it might be across multiple sites. It's not broadly available to the public. So there's an exemption for immediate circle. There's also an exemption for, I think it's called same area or same place, which ensures that there is not an obligation placed in respect of services provided at a particular and specific location. And what the effect of that, if I can translate that into common services, would be that the Wi-Fi that you might access through a chain coffee store or takeaway store or something like that, which is commonly provided, a data retention obligation would not fall on the person that is offering that service. That is not to say that there may not be data collected, because naturally there are telecommunications service providers who are providing data, but the individual coffee shop provider does not need to disaggregate the data in respect of his or her individual customers, but there is still data available in the relation to the use of that telecommunications service, because ultimately the coffee shop owner is a customer of a telecommunications provider.
Yeah. So what about Parliament House then, or a public library?
So the data retention obligations would apply to a service provider, the carrier or carriage service provider who is providing a service to a particular customer, and in respect of a public library, venue, etc., then the data retention obligations apply to the carrier or carriage service provider who is providing the end customer service to that library. The library itself doesn't need to break it down.
Who has to keep track of who's logged on to the free public Wi-Fi at a public library? Anybody or nobody?
Under the data retention obligation?
Yeah. Sorry, under the scope of your bill.
In relation to the individual uses of it, the library does not have to keep individual logons.
But therefore neither would the service provider that they're buying their services from.
The service provider needs to keep the elements of the data set in respect of their provision of the service, so the information about their subscriber, being the library, and the period over which that is used, and the information about the individual communications that are carried.
All right, what that tells to me is that if you want to avoid the national data retention regime that you're seeking to impose, you use the internet at a library, or come to Parliament House, or go to a free council hotspot, or use public transport.
I don't know that it necessarily tells you that, but it certainly does tell you that aggregation happens at a higher level. And again, as I said, I think in my introductory comments, I'd be reluctant to comment on the particular techniques that law enforcement and security agencies can use to support their investigations. I believe that they may have provided you with some advice to that effect in camera hearings.
No, we're not subject to those.
Sorry?
We're not subject to those.
Or a briefing, perhaps.
Oh, last year? Yes, that's true.
Yeah, I believe there were some briefings last year in which some of the agencies provided some guidance about what they may be able to do in those circumstances. But it is the case that, notwithstanding that, particular persons may use a range of strategies to seek to disguise their communications. And I should clarify, I don't know that I referred to it as illicit circumvention in any way.
No, the word you used was I believe it might have been abusive, but you weren't responding precisely to this question. So that's not a problem. I think you went more to how people would illegitimately try and disguise their traffic for mendacious purposes. But I'm actually interested in a whole separate category of people using services innocently or otherwise that would be completely out of scope and not caught by a national data retention regime. And it's that they would be caught. It's just a question by whom they would be caught. So the obligation does not apply. The obligation applies to carriers and carriage service providers. It does not apply to, for example, it does not impose a new obligation on all persons who provide access to their free Wi-Fi to their customers to now log their individual customers and to then be accountable and respond to data authorization. So that just tells me that it wouldn't be caught. If it's a university Wi-Fi on campus, for example, that means nobody is responsible for monitoring all and aggregating and providing later all that traffic.
The service provider still has an obligation in relation to their provision of the communication service to the university.
Well, what if it's the university? So they are going to be running a mail server, for example, or they're going to be running, a router that provides free Wi-Fi. The only thing that's going to be going back to Telstra or NBN Co in this instance is going to be bulk, just how much traffic was farmed out, not who it went to and how long the sessions were for. Is that you're nodding? But give
No,
Hansard.
look, I'm nodding because I'm not sure how much I can add without getting into some tricky territory, and I'd be reluctant to speak on behalf of agencies. But it is correct to say that there is no obligation in respect of the hypothetical university, coffee shop, public institution.
Yeah.
That may be providing its Wi-Fi services to its customers, visitors, etc. There is no obligation placed on those entities to record the individual use of that service by the individual people who come into their premises. Okay. There is, however, it remains the case that there is an obligation on carriers and carriage service providers to retain data in relation to their provision of services to those institutions. Mm. So the question is I suppose, a level of aggregation, and while there are certainly some limitations that are associated with that, and I think it was Victoria Police who reflected upon that in hearings on Friday last week, it is nevertheless the case that there is data that is available. The question is the additional steps that a law enforcement agency may need to take to make that data useful and intelligible to them.
Okay. All right. I suspect we might end up... I might put some more specific questions to you on this subject on notice. In terms of either intentional misuse or the increasing frequency of encrypted traffic, people using virtual private networks, people using the Tor browser or similar services, will any of those services be caught by the data retention regime? My understanding is they will not. In fact, that's precisely their purpose, among other things. And is it government policy to try and circumvent any of those things in order to bring them within scope of data retention?
Government's policy is to create a consistent but tailored and appropriate response to the challenges of accessibility of data, and it has done so by seeking to impose an obligation on carriers and carriage service providers providing telecommunications services within Australia, subject to both general exemptions which are on the face of the bill and potentially the application of specific exemptions that may be granted administratively on application by the service provider.
Are you worried that, or is the government worried, you don't have to express your degree of worry, I guess, that in striving for such extraordinary scope, you will in fact drive people towards default encrypted messaging and browsing technologies, which actually defeats the entire purpose of what you're up to?
Look, I mean, I think there's a number of competing challenges in terms of law enforcement access to the information that they would need to progress their investigations. It's fair to say that a range of considerations factor into government policy on both access to telecommunications data
I'm giving you some
broadly.
of those considerations.
Sorry?
Maybe be specific. Are you concerned, or have you even modelled the quantum, the number of people who will move their services to places that protect their privacy from precisely the kind of regime you're seeking to institute?
What we are aware is that there have been some studies. I think the UN Office of Drugs and Crime have looked broadly at this issue from the perspective of, how many offenders are starting to use encryption technology.
I didn't mention offenders, actually. I'm talking about ordinary people, but... go ahead with the study.
Obviously the intent of the bill is focused on people engaging in criminal activity.
No, it's not. It's rolled across the entire Australian population. That's why people are so pissed off about it. It's not targeted or discriminate at all. It's engaged at everybody. My 6-year-old nephew uses telecommunications services.
But it is intended to assist agencies who are focused on criminal and national security investigations. That's what their particular focus is on. That's why they're seeking access to the data. Okay. And that is why, it is acknowledged that data is part of a suite of investigative tools that agencies need to rely upon in order to progress investigations. They don't rely 100% on it, but it's an important aspect of investigative process.
Can we just come then to... I didn't get a clear read from you on whether the bill will cover the so-called over-the-top services, so people using Twitter direct messages or the Facebook Messenger app or Gmail. Will the data retention regime capture basic metadata from those services, the sort of stuff that's within the scope of the bill, time of email, maybe data volumes, recipient, that kind of stuff.
I apologise, Senator. I missed the very beginning of that,
So
of that question.
over-the-top services, so not Telstra, not iiNet, but Gmail, Twitter direct messages, Facebook messaging clients, other stuff like that. Are you seeking to be able to capture and archive for a period of 2 years basic metadata on those services in the 6 categories that the bill identifies?
So, well, I suppose there's 2 separate questions there. So the 6 categories define what data will be required to be retained in respect of the services that are covered by the obligation.
Yeah.
So I suppose the question of whether those entities are covered comes down to the application provisions rather than the data set itself. The data set itself will apply consistently to whomever is covered by it.
Yep.
And in terms of the entities that are covered by the obligation, those are the provision that those entities that are providing communication services through either carrier service provider or internet service provider, which is operated in Australia. And so in respect of a number of the examples, and I can't recall all of the ones that you named, it would be the case that those would not fall within the obligation. Okay. I think we've addressed some of the particular challenges that both over-the-top and offshore-based providers pose in our submission to the PJCIS, and made a couple of observations there that might be...
So if my email account is an @iinet.net.au address, it will be within scope. And if my email address is an @gmail.com, it'll be out of scope. So all I need to do to avoid mandatory data retention is just to take a webmail service.
I don't know that it's quite as simple as that for the reasons that I set out previously in relation to provision of telecommunications services.
Why is it more complex than that? If I use a cloud hosting provider or GChat or something like that, I won't be caught. If I use an iiNet or an Internode address, I will be caught. If it's more complex, please explain how it's more complex.
It's correct that iiNet Internode, as a Australian carriage service provider, depending on which part of the entity you're using, it is subject to the obligations. Gmail as itself, or Google as an entity, is not subject to the obligations. So that is in relation to the provision of the email service.
Are you trying to drive people away from Australian service providers?
I think we've articulated the intent of the bill, and the government's articulated the intent of the bill in terms of its coverage.
Is that an unintended consequence that you will be driving people away from Australian service providers?
No, Senator.
It's intended?
I wouldn't frame it in those terms, Senator. I think the government has made it clear that the obligation applies in relation to service providers who maintain their business and their infrastructure here in Australia.
Okay. Okay. We're running over time, so I thank you for your patience. There's been quite a bit of conjecture about the ability of civil litigants to be able to reach these new pools of data, recognising that you're not necessarily changing the way this material is accessed, but you will be changing the volume and types of material that's accessible and potentially how easily it can be accessed. Do you anticipate that civil litigants will be able to, through discovery processes, access the material that will be retained as a consequence of this policy?
So if I could just clarify one aspect of your question, I think you suggested that we would be changing how easily that information could be accessed. The access arrangements are only changing to narrow, not to increase. To
narrow the range of agencies that can get a hold of it. It appears to be a bit open-ended in that other agencies can be added to a list, but set that aside for a moment. Ease of access, by that I meant more that you'll be expecting to be able to access these new categories of data that will exist. It's going to need to be accessible and extractable and used for evidentiary purposes. So I'm assuming that means it may well be easier to access. But even setting that aside, do you anticipate that the material retained under the data retention policy will be accessible in civil matters?
Yep. So I think, as you said, we're not changing the access arrangements, save in respect of changing the number of agencies and prima facie reducing the number of agencies quite substantially from over 80 to around 17. So the access arrangements to data do not change, and so it remains the case that telecommunications data that is stored by communications providers is amenable to a range of lawful process, whether that be a telecommunications data authorisation under the Telecommunications Interception and Access Act, or whether it is in response to another form of compulsion through a discovery process, notice to produce, or such other framework. Yeah. It is the case, though, obviously, that any other form of lawful process needs to meet relevant thresholds, whether those be, for example, relevance in the course of discovery in civil proceedings or notice to produce. There are statutorily prescribed thresholds for access to that data. Those are not being changed through this process.
So it's more the volume of material that would be accessible. So I think that was a reasonably clear answer, so thank you. So, for example, US rights holders trying to track down and prosecute people file sharing, they could access this material under existing processes. It's just that there'd be a lot more material there to look for.
So I think that there's a range of... I don't know that I can answer that in detail in terms of a US entity seeking access to Australian information, etc. But because the access arrangements are not being changed, any access that is available at present in accordance with normal lawful process will continue to be available in respect of retained data.
But what will exist that doesn't exist at the present time is a 2-year record of download volumes, for example.
So what will exist, yes, will be a range of data that is not necessarily retained for that same period at the moment. So some data which is retained for a brief period will now be retained for longer. That's
right, which would be quite useful actually if you're a rights holder trying to find out who's downloading your stuff. I'll leave it there unless either of the other two senators... All right, thank you very much. Thanks very much for your time. Apologies that we went a little over. That was largely my fault. We may put some questions to you on notice, and because I'm not clear of what our reporting date is at the present time, I can't give you a deadline, but the Secretary will be back in touch. I promise it won't be too onerous. Is there anything else that you would like to tell us? Are there any questions you wish that I'd asked?
I don't think I've ever been asked that before. I think I can answer on behalf of all my colleagues to say no.
No,
thank you, Senator.
Okay. Thanks very much for your time. And
thank you.
What will we do? We will declare the hearing adjourned. I thank all witnesses who have given evidence to the committee today. I thank my colleagues. I thank Hansard Broadcasting and particularly the Secretariat, who are amazing, and declare the hearing adjourned.